Hello. I'm going to talk about history of special education as we see it being developed through the law. Now, the law has been very important in the development of special ed services, and what I've done is broken down into 8 what I believe are really critical events in the history of special education law, and how they encourage us to have greater expectations for youngsters with disabilities. It's also important to understand that these events are, I'm not going to talk about them in the detail that we go into in Chapter 3, but it's really important that we understand that special education didn't just happen on its own. It really happened as a result of parents and teachers and college folks getting together and advocating for the rights of students with disabilities. So the first critical event in the history of special education law is the heroic individual and group efforts. These efforts were parents getting together to advocate for their youngsters with disabilities, teachers, college professors, students in colleges getting together and trying to advocate, and in fact, in many cases, developing their own curriculum, renting places in school buildings, in libraries and public buildings to educate their children, but very little in the way of open public education. Now, the first critical events really occurred in probably the early 1900s up to 1918, where states were passing compulsory education laws that required that all youngsters in states would receive a compulsory public education. That was the case in every state, certainly by at least 1920. However, that didn't include youngsters with disabilities. They could still be excluded from public schooling at the whim of the school board, or even a principal at a school could decide, I'm not going to educate youngsters with disabilities. Well, what parents began to do is trying to advocate for their needs, going to school board for their children's needs, going to school boards and legislatures, and they began to coalesce to advocate as groups. And one of the first groups was the Council for Exceptional Children, 1922, formed out of Columbia University in New York by Elizabeth Farrell, a teacher there, and her students and some parents and teachers in public schools got together and formed the Council for Exceptional Children and began advocating for the rights of their children. Other examples included a group of mothers of retarded children from Cuyahoga, Ohio, who got together in 1933 and developed curriculum and rented spaces for education. Then in 1950 in Minneapolis, the National Association for Retarded Citizens was formed, which is now called the ARC. And all these organizations wanted to advocate for the youngsters with disabilities to be educated in public schools. Unfortunately, they were not particularly successful. It was very uneven. Some states actually did some good things, like Minnesota had a wonderful law. Other states, not so well. Now, in 1954, an event occurred that had a great impact on special education, and that was the United States Supreme Court decision in Brown v. Board of Education. Now, we all know that that was perhaps the most significant Supreme Court decision in the 20th century, and it involved racial minorities and culturally diverse children not being educated in public schools through a doctrine which at that time was called separate but equal. Earl Warren in the Supreme Court got together, or developed, took 5 different cases, including a case from South Carolina called Briggs v. Elliott, put them together into one case, Brown v. Board of Education, and unanimously ruled that separate was not equal, that children of color could not be educated apart from white children because that would be unconstitutional. Well, what happened is parents and advocates of youngsters with disabilities took their cue from this and started going to the courts instead of just to legislatures to get their rights passed for their children with disabilities. Now, one of the most important things that we find in the decision was this statement by Chief Justice Earl Warren, who wrote the majority opinion. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right that must be available to all on equal terms. And that was the key phrase. When a state undertakes to provide public education to some, it must do so for all on equal terms. The advocacy organizations then went into different states and went to the courts. Two very famous cases were Pennsylvania Association for Retarded Children, often just known as PARC, v. Pennsylvania in 1972, where a young lawyer named Thomas Gilhool looked at the Brown decision and applied those same principles when he sued the Commonwealth of Pennsylvania, saying, you've undertaken to educate your youngsters, your citizens. You have to do so for youngsters with disabilities. Similarly, in Washington, D.C., there was a case called Mills v. District of Columbia Board of Education that essentially held the same thing. These have been called the right to education cases. They were both decided, the consent decrees decided in favor of educating youngsters with disabilities in public schools, and started a wave of decisions throughout the United States. In fact, there were, I believe, 38 right to education cases brought in many states throughout the country to ensure the rights of students with disabilities. So really the writing was on the wall. The courts were going to make school districts and states educate youngsters with disabilities and on an equal basis with children without disabilities. And so states started to pass laws. And these laws tended to be rather uneven. Some states, like I mentioned, Minnesota, had very good laws. Other states did not. And so what happened is whenever there is a disparity in the United States, oftentimes Congress is going to try and get involved. And that's what happened in 1965. The early federal involvement included 4 basic laws passed. The Elementary and Secondary Education Act of 1965 had a section addressing youngsters with disabilities and their right to be educated, although it really just gave money to states to ensure the education. There was no teeth to the law. And so what happened in the early 1970s is Congress looked and saw all these disparity, this variance in public laws ensuring the rights of kids with disabilities to receive a public school education, and noted that there was such a great disparity. Some states doing a real good job, some states doing a not so good job, some states doing nothing at all, that they decided we need to fix this. And so the way they decided to fix this is by passing laws. They weren't sure how to do it, so they undertook to do 2 things. First, they passed Section 504 of the Rehabilitation Act of 1973, which we're going to be talking about in a few lectures. And they also passed what was called the Education of the Handicap Amendments of 1974. Both were efforts to get kids with disabilities into the public schoolhouse door. One, Section 504, was by declaring all persons with disabilities a protected class under the law. And then the Education of the Handicapped Act was actually a law that provided funding to states to ensure that kids would get a free, appropriate public education. The year after 1974, Congress enacted the Education of All Handicapped Children Act, which was really an amendment to the Education of the Handicapped Act, which really put teeth into the federal effort to educate youngsters with disabilities. Now, there were a number of principles of this law, and we're not going to talk a lot about them now. We'll talk about them more a little bit later. But districts were required to find children with disabilities, evaluate them, develop a free, appropriate public education that met their individual needs by crafting, along with parents, an individualized education program, or IEP. There was a section of the law on least restrictive environment, which said students with disabilities must be included with students who do not have disabilities. And there were a number of due process procedures that were written into the law to ensure that parents were equal partners in the development of their child's education. Now we're going to stop here for a minute, and I'm going to pick it up in the next lecture. But those early efforts were so important in ensuring that all youngsters with disabilities of school age would be able to be educated in public school environments.